confess to wrongdoing. You understand you have that right?
Yes, sir.
You also have the right to a jury trial. That means that you and your attorney and the state could select 6 people from a pool of disinterested citizens that would hear the entire trial, all the evidence, testimony, whatever is presented for your consideration or their consideration, and they would decide whether you're not guilty or whether you have in fact been proven guilty beyond reasonable doubt. You understand you have a right to a jury trial?
Yes, sir.
In addition, you have the right to confront witnesses. What that means is if you decided to go to trial, the state would have to try and prove your guilt by submitting testimony from witnesses, a witness or witnesses, if any. And in fact, then you and your attorney would have the right to question, cross-examine, or challenge any witness who would testify. It's called the right of confrontation, facing the accusers. You understand you have that right?
Yes, sir.
You also have the right to appeal. When all is said and done and all the dust settles, you and your attorney, individually or together, could demand that a higher court review the official record in this proceeding and all the evidence. There is an official record being prepared by the court reporter, Ms. Kayleen Rivera. In addition, that right of appeal would have to be carefully done because it's got the technical requirements, including substance and form of the paperwork, and it has time limitations. But you have the right to appeal. Is that clear?
Yes, sir.
In addition, there is a right to demand that this proceeding be held in the open public courtroom. Now, because of the COVID pandemic, we've been very slow to try and get things going again on open public courtroom, and we still haven't done it. But it requires your agreement and that of the state, because the state has the same right. It requires your agreement to or consent to conduct this by video conference. Do you understand you have that right?
Yes, sir.
All right. I just talked to you a moment ago about the right to video conference or your consent. Did you, in fact, review documents with the consent and the guidance of your attorney, Ms. Hernandez?
Yes, sir.
All right. One of the documents, as I just mentioned, is the consent to video conference. Also, there's a very important document. They're all very important, but one that's critically important is titled Defendants Waiver of Constitutional Rights and Court's Admonitions. Those rights that I just talked to you about momentarily, they are now in writing. This document specifically talks about the rights that you're giving up. And it also includes the requirement that you review these and sign them with the consent, or I should say with the guidance of your attorney. Did you review this document and sign it?
Yes, sir.
There's a document called a plea agreement. That document includes what you're agreeing to, how you're doing it. It talks about what you're charged with, what you're pleading. It has acknowledgments on your part concerning your rights. It has a multitude of paragraphs in there, or sections 1 through 14, that tell you, among other things, that the deal you're making with the state, it is not binding on me as the judge. As the judge, I have the authority and responsibility to say yes or no to your plea bargain. I have to say one or the other. I also have the right and authority to assess a punishment within the proper range of punishment for whatever offense you are pleading to. If I reject your plea bargain, or if I give you a punishment that's greater than what you agreed to, can you see and hear me?
Yes, sir.
This thing went crazy on me again. Excuse me a second while I try and get back in. I've got a dead screen here.
We can see you and hear you, Judge.
Okay. All right, now I'm back in where I can see everybody too. All right, now, did you review the document titled Defendant's Waiver of Constitutional Rights and Court's Admonitions with your attorney, and did you sign it?
Yes, sir.
There's another. Well, if y'all can see me, I appreciate you letting me know, because I have now had it.
We
I've
can
got
see you,
another-
Judge.
I've got another blank screen. Anyway, so now there's a document that's titled, or that I personally, as the judge, I certified to you. It's called the Trial Court Certification of Defendant's Right of Appeal. That is a document wherein I inform you that because you're participating in a plea bargain agreement, you do not have a right of appeal. You're giving that right up. Did you understand that document and sign it?
Yes, sir. Yes.
All right. Now, you have also agreed, you've entered into agreement with the state. And did you sign what's titled plea agreement?
Yes, sir.
Okay. Now, state, do you have a motion in this case?
Yes, Your Honor, the state would move to waive the extreme intoxication language and proceed on a DWI first.
Is it extreme or is it the can, open container?
I have
docket-
extreme intoxication marked.
Okay, Ms. Hernandez, you have extreme also?
Yes, and no objections, Your Honor.
Okay, so the state moves to waive the okay, I'm a little concerned because my docket says intoxication with open container. However, the court will take the motion as a waiver of the enhancement, whether it's extreme intox or whether it's open container, and that motion is granted. Therefore, you are pursuing a DWI first, state, is that correct?
Correct, Your Honor.
All right. Ms. Nichelle, do you realize that your attorney then and the state have agreed to reduce this from enhanced, especially in your case, extreme DWI, to what is in fact referred to as a DWI first or misdemeanor B? It has a lower punishment range. You understand that?
Yes, sir.
Okay. So, and what form of probation is she applying for, folks?
Or deferred adjudication?
All right. Thank you. Ms. Dennison, you will be, you have in fact, as part of your plea agreement, you're agreeing to apply for deferred adjudication. That is a special form of probation, also known as community supervision. That means instead of going to jail for a jail term, the punishment, whatever it is going to be, as far as jail, is going to be deferred or postponed. The important part, and critically important part of this plea is that if you live up to 100% of the conditions of supervision, then the case gets dismissed and you're not convicted of DWI first, not even that one, the one that's the lower one. Do you
Yes.
understand?
Yes, sir.
All right. So if you fail or refuse to live up to the 100% of the conditions, and I mean that very literally, 100%, then the state may ask that I give you official notice and bring you in for a hearing, at which, if I believe it is appropriate, I can then enter a complete conviction of you that follows you the rest of your life. You understand that that is a consequence if you don't live up to 100% of the conditions of supervision.
Yes, sir.
All right. State, what is the agreement?
The agreement is for 14 months deferred adjudication, $500 fine, but propate half, 48 hours community service, DWI education program, victim impact panel live, top evaluation, and ignition interlock for half the term.
Ms. Hernandez, is this your understanding of the agreement?
Yes, that is the agreement, Your Honor, but we would like to speak to the ignition interlock to make the court aware of the situation whenever possible.
We'll attend to that shortly.
Yes, Judge.
Ms. Dennison, is this your agreement?
Yes, sir.
All right, before I proceed, I need to know, first of all, do you have any children that you support?
Yes, 2.
Minor children?
Yes.
How many do you have?
A 6-year-old and a 4-year-old, 2.
Okay, 2 children. And how do you make a living? How do you support yourself and your children?
I'm a hairstylist and I work full-time.
Mhm. And approximately, what is your income, total income on a regular basis per month?
I would say about 1,800.
1,800, you say?
Yes.
All right. Do you live with the father of the children?
Yes.
All right. What does he do for a living?
He does not work right now. He's in school.
Okay. How long has he been in school?
He graduates next month and he's been in school for going on 7 months.
And what will he be doing once he graduates?
HVAC, AC.
Okay, air conditioning?
Yes, sir.
All right. Well, that's good. The court is inclined to approve this agreement, but at this point, Ms. Hernandez, will you talk to me about the ignition interlock issues?
Yes, Your Honor. As far as ignition interlock, the family has only one vehicle. Her family uses it. She uses it to go to work and take the children to school, and her husband is a college student. So I didn't know if there would be an issue with ignition interlock. And so we wanted to address the court and see how you wanted to handle that, Judge.
Well, you do have access to that vehicle, right? And you do use it some.
Yes.
Okay. I will go ahead and impose the ignition interlock. I realize it might be a bit of an embarrassment to your husband, but and he does not deserve it. But the requirement is that we impose it since you have access to and do use the vehicle. All right. So then the court, what officially is your plea, ma'am? How do you plead officially?
No contact.
All right. The plea is no contest. You understand that a no contest plea in this court is considered a guilty plea and is sufficient for me to convict you by itself.
Yes, sir.
All right. And did anyone threaten you, intimidate you, or promise you anything other than the plea bargain in exchange for your plea of no contest?
No, sir.
Very good. Then I accept your plea of no contest. I find that there is sufficient evidence to find you guilty, but I do not. I will honor the agreement on the deferred adjudication. In fact, I grant you 14 months deferred adjudication. You have a $500 fine, of which one half will be probated, meaning if you live up to all the conditions, you'll only pay 1/2 of that fine. You will perform 48 hours of community service restitution. You'll complete in good faith a DWI education program, a victim impact panel live, you'll submit to a TAP evaluation and the recommendations subject to the court's approval. You'll have ignition interlock installed in your family vehicle for 1/2 the term, which is 7 months. Your supervisory fee, I'm going to make it the minimum under law since you're having to carry the load right now. It'd be $25 a month. Anything else, State?
No, Your Honor.
All right, just for the record, ma'am, you will be required to come by the offices of the County Court at Law Number 5 so that you can have your thumbprint placed on the documents as required by law.
Okay.
In addition, you will have to stick around here. Do not leave this meeting until you have met with Ms. Maricela Luna, who is going to explain to you how your probation program will work. Among the things that I want you to be aware of is the probation department is going to read to you at one point. They will read to you every one of the conditions of probation, the deferred adjudication, and you will sign those conditions. You will sign those conditions and they will put a copy in your hands. Do you have any questions, Ms. Dennison?
No, sir.
All right. Let me just remind you briefly. The worst thing that could happen in your life is for you to be drinking and driving and you kill your children in an accident because you aren't capable of driving and drinking. That's the worst thing that could happen in your life. The second worst would be to drink and drive and kill an innocent person. Someone that's not family, but yet that would not deserve it, and you would do that. Keep that in mind, ma'am, because it can happen and you see it and read it on TV and newspapers all the time. People don't start out in the morning thinking, well, today I'm going to go out, drink and drive and kill my kids, or drink and drive and kill somebody. But they do it. How do you think it happens, man? They drink and drive. So be aware of that, please, and
Yes, sir.
take care of yourself and your family, okay?
Thank you.
Good luck to you.
Thank you.
All right. Patty, you going to put Ms. Luna and Ms. Dennison in breakout?
Yes, sir.
All right. Now, the court calls case number 612-311, State versus Afua Adu. This is a motion to enter adjudication of guilt.
Yes, good afternoon, Your Honor.
Right.
Pat Montgomery for the defendant, Your Honor, Afua Adu.
Good morning or good afternoon, Pat.
Good afternoon.
I hope I'm pronouncing this somewhat correctly. How do you pronounce your name, ma'am?
It's like Sophia, but it's Afia.
Afia. Okay, I'm sorry. I keep saying A-F-U-A, Afua.
You know, it's a complicated.
Same thing, Judge. Sorry.
No, it's all cultural and family and all that. So it's Afia Adu.
Yes, sir. Thank you.
All right. And this is an MTEAG on an obstruction. It is 1:59 p.m. State, your motion.
Yes, Judge, we would call the supervising officer
Sylvia Sorolla.
Yes, ma'am. Present.
Ms. Sorolla,
Good morning. Good afternoon, Judge.
good afternoon. Would you please raise your right hand? You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth, so help you God.
I do, sir.
Thank you, ma'am. You may put your hand down. State, proceed.
Ms. Sorolla, how do you know Ms. Adu?
I have been supervising her from the day that she got placed back on probation. Her first meeting with me was in April of 2021.
Okay, and how would you describe her participation in probation under your supervision?
In regards to her classes, completing her classes, she was slow to make progress in completing her classes. We usually recommend that any classes that judge orders, especially for any.
Judge, I'll
alcohol-
object to the narrative, and I'll also object that the response is not relevant to any of the 6 alleged dates in the motion to adjudicate and the supplement to the motion to adjudicate. So 1, it's a narrative. 2, it's not relevant.
On the narrative, I'll sustain, state, make it question and answer. On the relevance, I can only say that it seemed to me to be relevant, but at
Well,
this point,
there's no
that'll be,
allegation. I'm
at this
sorry.
point, I'll overrule your objection on the basis of relevance. However, you certainly can glean or show further on questions that are produced, whether you're right or not.
Yes, sir.
Proceed, state.
Ms. Sorolla, are you aware of the alleged violations?
Yes, I am. Yes, ma'am.
Okay, and are you aware of the violation from the 11th day of June, 2021?
Let me get to that motion. Give me 1 minute. Sorry. Okay, so you're talking about the number 15 on June 11th of 2021, that there was a
Yes.
skipped from 5 p.m. to 8 on the window? Yes, ma'am.
Your
How
Honor,
are,
I take the witness on voir dire.
You may.
Ma'am, all I know about is the records that you're looking at. You don't have any personal knowledge whatsoever regarding whether or not there was a skip test or not on June 11th, 2021. Am I correct?
Excuse me, may I say something?
Sir,
It's a
You have,
haven't-
hold on. Ms. Sorolla,
yes, Judge.
did you understand the question?
Yes, Judge, I understood the question. He's
Okay,
asking
then-
me if I have personal knowledge.
That is correct. You can say yes or no.
Judge, I was not there personally in her home, but as probation officers, to inform the court of any violations, it is done through a report given by our providers.
Your Honor, I would object to the witness's response, and I would argue that the witness is testifying in 1, hearsay, and 2, in violation of my client's right to confront and cross-examine accusers, namely whoever the people are that manage and operate these machines that could or could not testify about a missed test on June 11th, 2021.
All right, first, hold on. We do this by the rules, and I realize they're technical. So first of all, on the question of no personal knowledge, she has answered to some extent that she does not have personal knowledge. At this point, that objection is sustained. State, you may ask your questions in a different form or manner if you choose.
Are you aware of the rules and regulations that are a part of the PAM devices?
Yes, ma'am, they are giving rules and they're giving a sheet and they're explained at the time that they.
Hold
obtain-
on, Ms. Sorolla. I'm sorry. Listen carefully to the question, otherwise we're going to be here with 1,000 objections from Mr. Montgomery. Listen carefully. I know that there's a lot of information you can and will give us, but take it one step at a time. She asked you one question, don't answer it and try to explain. That's not your job.
Okay, sir,
Okay.
thank you.
Alrighty, just take your time. We'll get there.
Hmm.
Now, Ms. Pollard, you may continue. The answer to, are you aware of rules and regulations? That's a yes.
Yes.
What are some of those rules and regulations?
That they're supposed to meet the financial responsibility of the device. They're supposed to follow the rules, which include test windows and times with the dates that they're supposed to, the days of the week that they're supposed to test.
And as the supervising officer, what is your role in regards to those rules and regulations?
My job is to make sure that the person who has the device follows and provides test windows accordingly, according to the rules that they were provided when they obtained the PAM device. And
How do
also to report any violations to the court.
And how do you do that? How do you monitor that?
As a probation officer, we monitor that information by a report that's sent to us by the provider of the device.
And then when there are violations on those reports, you said you alert the court, correct?
That is correct, ma'am.
And you were supervising Ms. Adu on the 11th day of June in 2021, correct?
That is correct.
Were you made aware of any of the violations of those rules and regulations that you monitor on that day?
Objection calls for hearsay, Your Honor. Also potentially invoking my client's right to confront and cross-examine witnesses against her.
Okay. Perhaps I'm going to sustain that, Ms. Pollard, or perhaps you can take it a little more specific on the methodology of getting her to testify.
Okay, Judge, one moment.
If I may take this opportunity, Judge, while she's conferring with co-counsel Ms. Adu, you'll have an opportunity to speak, but right now it's like we're in a courtroom and it's like Ms. Sorolla was up on the witness stand. You wouldn't just jump up and start talking if we were in a courtroom and Ms. Sorolla was on the witness stand. So we kind of got to follow our rules.
Understood. Thank you.
Thank you, ma'am.
Ms. Sorolla, do you know if she submitted every time that she was supposed to?
You want to clarify that submitted to, you mean the breast
Followed
samples?
the rules and regulations that you had explained earlier?
Judge asked and answered. She's already said she doesn't have that personal knowledge.
I don't think that specific question was asked. And to that specific question, I overrule the objection.
Yes, sir.
You can answer.
To my knowledge, I reported her skip test windows and any other violations to the court accordingly.
You would report those skipped tests. Is that what you were saying?
That is correct, Ms. Pellard.
Did you report a skipped test for Miss Adu?
Yes,
What days did you do that?
for June the 16th of 2021, she skipped, no, I'm sorry. It's June 11th, 2021. She failed to provide a breast sample from her 5
Objection is
p.m.
not responding. The question was whether or not she reported a skip test, not whether or not she skipped a test. The witness has already said she has no knowledge about whether or not test. I could take her on voir dire, or we could stipulate that she doesn't have the personal knowledge. But I have no objection to her telling the court that she's reported it because she had a duty to report it and indeed did. But I do have an objection if she's stating it as fact. And the objection there would be confrontation and cross-examination, Your Honor. I know it's a nuance, but I feel like it's important, Your Honor.
I understand. I'll sustain the objection. Now, Ms. Pollard, the information you're seeking to glean is available, but you have to get it in a format or a form that is within the rules.
Yes, Judge.
But we do have a report. She reported that the lady skipped a window on 6/11/21.
Judge, I think at this point we would pass the witness.
I have no questions for this witness, Judge.
All right. Ms. Sorolla, can she be excused? State, you have anything further, Ms. Sorolla?
No, Judge.
Mr. Montgomery, you passed, did not have questions. I presume you have no objection to her being released.
No, ma'am. Nice to see you, Ms. Sorolla.
Thank you, sir.
You're excused, ma'am. Thank you for your time and for being here.
Thank
All
you,
right.
Judge. Y'all have a great afternoon.
Next question or next witness, Ms. Pollard.
Judge's state doesn't have any other witnesses.
All right.
Judge, I request a ruling denying the motion to enter adjudication of guilt. I submit to you that no evidence as a matter of law has been presented on any of the allegations in the motion to enter adjudication, as well as the supplement to the motion to enter adjudication. There was only an effort to provide evidence on June 11th of 2021. And the witness testified that she reported to the court that a window was missed, but she did not testify that indeed the window was missed. I submit to you, Your Honor, that it hasn't been proven by a preponderance of the evidence. I ask you to allow my client to continue her deferred adjudication community supervision, which expires on December 29th of 2021.
I'm going to deny your motion, Mr. Montgomery. I note your argument is quite succinct and appropriate. But this is a motion to enter adjudication of guilt. It is not the same as proving beyond reasonable doubt. Technically speaking, one missing of a window is probably sufficient to find that there is a violation, because I personally instructed people that get put on probation to obey 100% of the conditions of supervision. Since the court also has the responsibility to supervise persons on deferred adjudication or whatever probation we have, in this case it's deferred adjudication, I have the authority to amend the conditions. Ms. Adu, have you ever been placed on antabuse, ma'am?
Can you hear me? I'm sorry. I
I hear you
apologize.
now.
Thank you. I'm sorry. You said, have I been placed on what again, sir? I'm sorry.
And antabuse, those pills where you can't drink at all.
Antabuse? No, sir.
All right. Have you ever been placed on any other stricter devices for supervision?
This is my first charge, sir. I haven't had any type of probation prior to this, nor any type of violations of the law. So device that I've ever been on, sir.
Let me make real clear to you that there's another device that I don't have to worry whether there's windows or not. It's called Scram. And it costs over $300 a month. But it supervises you 24 hours a day. It's a bracelet type thing that if you dare to drink one little sip, it'll show up and report to a device that receives the information. Do you hear what I'm saying to you, ma'am?
Yes, sir.
Now, the fact that Mr. Montgomery has very skillfully made it clear that no matter how many times you may have missed windows, whether it's 1 or 100, the evidence has to be within the rules of the courts of the law. But that doesn't mean that I am bound not to put you on Scram or any number of things, including antabuse, which you would not enjoy because you got to be going 2 or 3 times a week, taking a pill to make sure you're not drinking. Do you hear what I'm saying to you, ma'am?
Yes, sir.
Now, you were reported for missing, in this case, there was one window. I have no doubt that there were more, but that's not a matter of established evidence. I'm going to deny, Afia, I'm going to deny the motion to enter an adjudication of guilt. But let me promise you that there are several things we can do. You violate these rules, we can extend your probation, even if I don't revoke your deferred adjudication. I can put you on scram. There's a number of things I can do. Are you hearing what I'm saying to you, ma'am?
Yes, sir, absolutely.
I hope you really listen, because the fact that Pat Montgomery is skillful enough that I'm not going to revoke you at this point doesn't mean that I can't amend you all kinds of ways. It's called winning the battle but losing the war, okay? You're still in the war. And this battle, Mr. Montgomery has very skillfully won. Don't put me to the test, because I'm sure that the state and the probation office would be happy to ask me to amend your conditions. And that is something I can do just because I say so. Okay?
Yes, sir, absolutely.
Do we understand each other clearly?
Very clearly, sir, yes.
All right. Mr. Montgomery, you have done a skillful job today, but I ask you to be cautious and talk to your client, because you know what I'm saying to you.
She's always been good with staying in touch with me over the telephone, and we'll talk on the telephone again after this hearing is concluded.
I'm sure you will, and I would appreciate if you do that. All
Yes,
right,
sir.
that concludes this.
Your Honor, I need to address something with you. Mr. did some community service hours that were not approved in the agency list, nor was a report done to you to approve those hours. The officer was going to send the report, but Ms. Adu had already done them. So I'm not sure if you want to go ahead and give her credit for those hours she already did.
Thank you, Miss Luna. I forgot that entirely. Judge, I have written proof that she worked on call it a hotline at a bereavement center. And she spoke to people who would call in when they were suffering through bereavement. This is the documentation that was sent to me. She provided that documentation to probation. She did enough hours, it would have satisfied her community service requirement. But because the bereavement center was not on, I guess, some approved list of community service places, they did not approve it toward her probation. I can show it to you in a share screen if you want, Judge, I think.
Oh, no, Mr. Montgomery. You have just now succeeded in this hearing because you held the state to the rules and the law. I appreciate that. I respect that. Now you're asking me bend the rules because she did a good job. She did something right, but the fact is she didn't go by the rules.
Yes, sir. I was following up on.
I hear you. I understand.
Yes, sir.
So let's split the circumstances. How many hours is she supposed to do, Ms. Luna?
64 hours, Your Honor.
How many?
64.
All right. In good faith, Ms. Adu, I'm going to give you credit for half of those, 32. But the other 32, you're going to do on our ticket. You're going to do in accordance with our rules. Understood?
Yes, sir. May I ask, what do I need to go to a specific website or office to be able to retrieve the specific list of places that I could go to?
All you got to do is ask your probation supervisor and they will provide it.
Okay. It was just because the reason why I went to that specific woman again was because I initially had actually completed 40 hours back in 2020 for community service hours, just for good character. And then I went to the same woman again for the 64 hours once again. So I was at the same office twice. So that's why I thought that it was under, like, it was going to be acceptable because it was accepted the first time. I do
Well,
apologize.
maybe this is a little bit of a lesson. Be careful what you do and how you do it. Follow the rules to the T.
Yes, sir, I
know that when I put you on deferred adjudication, what numbers did I use to tell you what you had to obey? 100% of the conditions of supervision, not 50%, not 20%, 100%. Okie doke.
Yes, sir, absolutely.
All right, let's stay on the same page. You'll be through in a month or two, but do it on our rules, not as you may choose. And probably what you did was a wonderful thing and a good thing. But let's, if everybody, that's our problem. If everybody does or follows the rules in accordance with their own choices instead of what we require, then we'll have chaos and we'll never get things done. All right. Anything else, ma'am? Ms. Luna, make sure that she gets 50% credit, and the rest she'll have to do on our ticket.
Yeah, so she's, the motion was denied.
That's correct.
And it was going to be continued and give 32 hours credit. Is that
That's correct. Yes.
Okay.
All right. Ms. Adu, good luck. Be careful. Mr. Montgomery?
Thank you, Your Honor.
All right, guys.